Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, big ruling out of the Second Circuit. We're going to geek a little bit out of the ruling, but we're going to use it as a teachable moment because I know a lot of you could actually end up in this same spot because it doesn't really take a very irresponsible person to end up where the defendant ended up here. But it begs a question. I get it asked of me once in a while, and it's a question that I think you as an everyday carrier needs to be aware of, especially if you're carrying your firearm in your car. So today, with the help of the Second Circuit, let's talk about, can police handcuff you and search your car just because you have a gun? Okay, America, this is what we're talking about. We're talking about the case of Soukaneh versus Andrzejewski. Now, this is a case that was on appeal to the Second Circuit. The Second Circuit has affirmed the trial court, and this is a big ruling as it relates to both qualified immunity, but what we're going to talk about is an issue that you may yourself accidentally run into. The question here is can police just pull you out of your car, throw you in handcuffs, stuff you in the back of their patrol car, and then search every inch of your vehicle simply because you are lawfully possessing a firearm? Well, that was, in many ways, the issue that was decided in this case. The bottom line is no, they can't, okay? Let me explain why this could possibly happen. I know some of you probably live in jurisdictions where no officer would ever do that, and candidly, I've been pulled over a few times by Washington State Patrol troopers, handed my license, handed my CPL. They're cool, I'm cool. Everybody goes about their business just fine. However, if you live in Waterbury, Connecticut, that may not be the case. You see, Mr. Soukaneh, the one-time defendant on this case, pulled over in a high crime area. And no one disputes that this was a high crime area. Now, there's no evidence to suggest that Mr. Soukaneh was engaged in any type of illegal activity. But that didn't stop Officer Andrzejewski from absolutely rousting him. He went over immediately, knocked on the window, demanded to see some ID. Mr. Soukaneh did hand him some identification as well as what appeared to be a valid concealed carry license. Well, that sent the officer into a tizzy fit. According to evidence, he pulled Mr. Soukaneh out of the vehicle violently, handcuffed him, shoved him in the back of the patrol car, and then proceeded to search every square inch of his car without a warrant. Now, the question is that lawful? And I know your gut instinct is I don't think so. And you're right, okay? But we're going to give you a more technical answer so that you could understand. Now, what happened here is Mr. Soukaneh sued the officer under 42 United States Code Section 1983 saying, hey, you violated my constitutional rights under the color of state law. The constitutional right, of course, being a violation of his Fourth Amendment right to be free from unreasonable searches and seizures. The officer here, Officer Andrzejewski, moved for summary judgment saying, no, this happened in the course of my duties. I got qualified immunity. You can't sue me. The trial court went, no, he does have a claim against you. You did violate his Fourth Amendment rights. So he crapped his pants, appealed to the Second Circuit. Now, let's remember the Second Circuit is the same court that upheld New York's May carry regime, which ultimately became New York State Pistol and Rifle Association v. Bruin. So not the most pro-Second Amendment court, but they have upheld the trial court here. They have said, yeah, you know what, officer? You did violate his Fourth Amendment. Even though you found him in possession of a firearm, there was nothing to suggest that the firearm was unlawful. There was nothing to suggest he was engaged in any illegal activity. And you, therefore, basically produced what we're going to call a constructive arrest, okay? And we'll explain that in just a moment. The evidence taken in light most favorable to plaintiff appellee Soukaneh would permit a reasonable jury to find that in the course of a routine traffic stop, Andrzejewski unlawfully and violently handcuffed and detained Soukaneh in the back of a police vehicle for over a half hour and conducted a warrantless search of Soukaneh's vehicle after Soukaneh presented a facially valid firearms permit and disclosed that he possessed the firearm pursuant to the permit. On appeal, Andrzejewski argues that we should reverse the district court's denial of qualified immunity because the presence of the lawfully owned firearm in the vehicle gave him the requisite probable cause to detain Soukaneh, search the interior of his car, and search his trunk. Okay, so I want you to understand what the officer is claiming here. What the officer's argument here is because I had evidence to believe that he was in possession of a firearm, and yes, all evidence suggested that he was in lawful possession of a firearm. That gave me the authority to detain him. But here's the thing, okay? If we're going to talk about putting handcuffs on a person, shoving them in the back of a car, you can call it whatever you want. But the minute you throw handcuffs on a person and you shove them in the back of a patrol car, that's an arrest. That is a constructive arrest. Whether the officer wants to call it an arrest or not, that is an arrest. An arrest must be supported by probable cause, whereas the initial detention of Mr. Soukaneh only needed to be supported by a reasonable and articulable suspicion. Now, to help you better understand this, anytime government is going to just inject themselves into your life in the way of a search or a seizure, they must be able to justify it on some quantum of evidence. The amount of evidence that is necessary to justify it is going to depend on how intrusive that seizure was by government. So, a traffic stop, for example, just a routine traffic stop, all you need is a reasonable and articulable suspicion, okay? And in this case, Mr. Soukaneh had said, I don't have any issue with him walking up to my car and demanding to see my ID. Okay, now, once we have a person detained, if we are going to place them in custody, we need something called probable cause. Probable cause is the existence of facts when taken amongst the totality of circumstances that would lead a reasonable person to believe more likely than not that the accused is guilty of that offense, okay? And I'm sure every jurisdiction has its own wording, but it basically means it's probably more likely than not that the dude did it. That is enough to justify the arrest. It's not going to support a conviction, but it's enough to justify the arrest. Now, backing up to the reasonable or articulable suspicion, if you believe that the individual may be armed and therefore pose a threat to officer safety, under the case of Terry v. Ohio, an officer who has reasonable or articulable suspicion may pat a subject down for weapons. However, that is the sole purpose of the search. It could be a bag or something else that they may have had access to. But in this case, all right, what the officer did is he didn't pull Mr. Soukaneh out for a pat down. No, he pulled him out. He cuffed him, he stuffed him, he let him sit there for 30 minutes, and then he conducted a search of the car. And understand there's only 3 ways that he's going to be able to lawfully do that. The first one is with a search warrant. Now, a search warrant has to be supported by probable cause. He didn't have a search warrant, and he wasn't going to get a search warrant because he didn't have probable cause. The second way he could have done it, of course, is he could have gotten Mr. Soukaneh's consent, but he never bothered to do that. And then the final way is you can search large portions of a vehicle on what's called search incident to arrest, which means had the officer had a lawful basis to arrest Mr. Soukaneh, he likely could have searched the car. But the court here has found, hey, you didn't even have a lawful basis to arrest this guy. The district court reasoned that Andrzejewski did not possess the requisite arguable probable cause to justify this conduct, explaining that a reasonable officer would not believe that Soukaneh was committing a crime or posed a meaningful threat of being armed and dangerous for merely disclosing the presence of the firearm and its accompanying permit. In fact, the last person who's going to probably try to do something nefarious with a firearm to an officer is the person who immediately tells the officer that he has a firearm. Qualified immunity. A lot of people get very, very critical of qualified immunity. A lot of people kind of don't understand what is qualified immunity. Qualified immunity is a level of immunity given to police officers and other professionals that so long as they are acting in good faith within the confines of their job descriptions, even if they turn out to make a mistake or be wrong, they can avoid lawsuit. But obviously, if you are willfully violating an individual's rights, then qualified immunity does not apply. As the court put it, qualified immunity shields officials when their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Okay, but if we are out absolutely blatantly violating constitutional rights that we know of, and by the way, the right to be free from search and seizure, pretty well known one, especially to law enforcement, then qualified immunity may not apply, as the court also pointed out. The Supreme Court has instructed that qualified immunity balances 2 important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties responsibly. And as the court found out, there is a 2-part test here to determine whether or not qualified immunity should apply, in this case, to Officer Andrzejewski. Whether the facts show, 1, make out a violation of a constitutional right, and 2, whether the right at issue was clearly established at the time of defendant's alleged misconduct. Well, what do you mean by a right clearly established? I mean, that seems a little vague, right? Well, the court actually has a rule of law for it. A right is clearly established when the contours of the right are sufficiently clear that a reasonable official would understand that what they are doing violates that right. Okay, now again, we're talking about a Fourth Amendment right to be free from unreasonable searches and seizures. So what the court here has said, to determine whether Andrzejewski is entitled to qualified immunity for those actions, we must consider whether Andrzejewski violated Soukaneh's constitutional rights against unlawful search and seizure, and if so, whether the violated rights were clearly established at that time. Now, the court basically said, hey, listen, you could call this a detention, you could call this a Terry stop, you can call it whatever you want. But when the facts tell us, and as they call it a de facto arrest, and out here in Washington we call it a constructive arrest, we're going to determine and we're going to treat this as if this is an arrest, which means it has to be supported by probable cause. There's also a Miranda thing that may kick in some jurisdictions as well, but that's a side note, okay? And in order to determine whether this is a de facto or constructive arrest, which this clearly was, by the way, the court looks at all of these factors. 1, the length of time involved in the stop. 2, its public or private setting. 3, the number of participating law enforcement officers. 4, the risk of danger presented by the person stopped. And 5, the display or use of physical force against the person stopped, including firearms, handcuffs, and leg irons. And of course, the court, based upon these facts, you got to understand, half the Waterbury Police Department showed up here to watch this fiasco. So the court had no problem making the finding that the present case satisfies nearly all of the de facto arrest factors. So, summary judgment motion denied. Mr. Soukaneh could proceed with his 1983 claim against the officer and try to recover money damages. Going full circle back to our original question, can a police officer handcuff you, throw you in the back of the car, and search every inch of your car simply because there's evidence that you possess a firearm? The answer is no, he may not. May he inquire further? Absolutely. Are you required to be honest with him? In many jurisdictions, there is statutes against lying to police officers, especially if they're going to rely upon those statements. Might he ask to have you briefly step from the car? It's possible. But in this situation, the officer was presented with a person who, at all accounts, was acting lawfully and was lawfully possessing the firearm. He then treated him as though he was arresting him for a Class A felony, shoved him in the back of the patrol car, called the rest of the police department out, and basically searched every inch of that car. He can call it whatever he wants. That is an arrest, and it's an arrest that was not supported by probable cause. Therefore, it is an unlawful search and seizure. The lesson for you, America, of course, is can an officer, upon learning that you have a firearm in the car, just pull you out of the car, handcuff you, shove you in the back of the patrol car, leave you there for 30 minutes while he searches every inch of your car? In almost all instances, no, he may not. Listen, we've done some videos before on how to deal with officers during a traffic stop should you be in lawful possession of a firearm with the car. We'll go ahead and link them up down below so that you guys can geek out on those for yourself. We'll go ahead and link the case up again. Soukaneh versus Andrzejewski. It's a brutal case to say. I'm sure I have been mispronouncing both the plaintiff and defendant's name, and I apologize. The order of the court is down below so that you can geek out on it for yourself. Maybe you got questions about this or anything else related to what's left of our Second Amendment rights. You guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down in the description box. Maybe you got an idea for a video. Go ahead and click on that link if you do. Maybe you just want to be part of our newsletter. The ability to subscribe is down there in the description box. And then finally, America, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.